A trial like this sometimes seems like a competition. Naturally, one side against another. Like we're competing against each other, like a boxing match or a football match or netball, or whatever it is. The truth is more like the high jump. More like the high jump. This is important. Only the prosecution has to get over the bar. Defence doesn't have to do anything. Defence doesn't have to jump any bar. Erin Patterson doesn't have to jump any bar at all. The prosecution has to clear the bar. And that's the highest bar known to the law. And that's where you are now.
To stick with Colin Mandy's sporting analogies, it was the final siren on the defence's argument on the innocence of Erin Patterson today. Her barrister talked to the jury for the whole day, telling them that probably and maybe are not enough to convict his client.
You are at innocent with Erin Patterson. That's your starting point. The starting point is innocence. She is presumed innocent of these charges. She doesn't have to prove her innocence to you because she is innocent. And it is for the prosecution to disprove her account of accidental poisoning beyond reasonable doubt before you can move from that position, before you can find her guilty of anything.
He talked about her testimony, Asian grocers, Erin's phones, and what he said were ridiculous propositions put forward by the prosecution. It was a big day and we'll break it all down for you. I'm Brooke Grebert-Craig and this is The Mushroom Cook. It's day 35 of Erin Patterson's murder trial and I'm here with my colleague, court reporter Laura Placella.
After 3 days, we've arrived at the end of Mr. Mandy's closing address.
Yes, we have.
So the jurors are done hearing from witnesses, they're done hearing from barristers, and next week, in the 9th week of this trial, they'll hear from Justice Christopher Beale. But more about that later. Today, Mr. Mandy picked up where he left off yesterday with the day after the lunch.
Yes, he started with the evidence that Erin was drinking coffee on July 30, and that's the day after that deadly meal.
This evidence came from Erin's son, who told an investigator that that morning when he woke up and came into the kitchen, he saw his mum drinking coffee. But when she was giving evidence, Erin said that she was actually drinking tea. Mr. Mandy said today, though, that it was perfectly reasonable for him to assume she was drinking coffee that morning, considering most days he would wake up to see her doing that.
Now moving on to Erin driving her son to a flying lesson that afternoon. Mr. Mandy told the jury the prosecution's case was that Erin was faking being ill, but he disputed this, saying, why would she go on this journey if she was faking being unwell? She would go to bed.
Our listeners may remember that it was on this journey to Tyab that Erin said she had to pull over on the side of the road to go to the toilet in a bush because she was experiencing diarrhea. She said when they later stopped at a service station, she went into the toilet to dispose of the tissues she had used to clean herself up. CCTV footage shows that she only spent 9 seconds in the toilet. In its closing address earlier this week, the prosecution argued that if Erin really did have diarrhea that day, she would have spent more time in there, at the very least, to wash her hands. But today Mr. Mandy made a point of saying that the prosecution didn't even ask her in cross-examination what she was doing in those 9 seconds while she was in the toilet.
Now moving on to Erin leaving Leongatha Hospital after 5 minutes on July 31. Mr. Mandy said she left because she was not prepared for what she walked into. These are his words, but not his voice.
An extremely intensive 5-minute interaction where she was told that she would be admitted and transferred to a different hospital in Melbourne. Dr. Foote told her that that's what needed to happen. So she was not refusing treatment, she was saying there were things she needed to do before she could be admitted and transferred. She had diarrhea, she was dehydrated, but she was still functioning, and she was plainly struggling to process what she was being told, and her mind turned to the practical considerations.
Mr. Mandy then took the jury to Erin's second presentation to hospital about an hour and a half later. He reiterated again that on the prosecution case, Erin was faking illness. But he said his client was reluctant to receive treatment that day because of her history of hating hospitals and discharging herself against medical advice. He told the jury that what she did that day was actually not consistent at all with what a person faking illness would do. In another theatrical moment from Mr. Mandy, he raised his arms and said the following.
The allegation is that she was reluctant to be admitted, to be hooked up to medications because she was pretending to be sick. But that's a contradictory argument. Can't possibly make sense. If you're pretending to be sick, you've got to be saying to the medical staff, "Hook me up, pump me full of drugs, I am very, very sick, please."
Now moving on to the Asian grocer, Mr. Mandy said it would have been remarkable if Erin gave everyone the exact same account as to what happened.
The jury has previously heard that in the week after the lunch, there was a medical investigation, a health investigation, a child protection investigation, and a police investigation, all underway at the same time. Mr. Mandy explained that there were many people asking Erin many questions about where the mushrooms in the beef Wellingtons had come from. In a previous episode, we ran through all the varying accounts Erin gave about the location of the Asian grocer. Today, Mr. Mandy explained why those accounts did vary.
Imagine that. If they all agreed exactly that she used the same words and said exactly the same things, it would be firstly totally unrealistic, and the prosecution would probably argue, in those circumstances, that it was very suspicious that someone had such a well-scripted account of what was going on.
Mr. Mandy then reminded the jury that during the Department of Health's investigation, an environmental health officer was never asked to check any Asian grocers in Glen Waverley. This was despite Senior Public Health Advisor Sally Ann Atkinson telling the court that she remembered telling this employee to check that suburb. Mr. Mandy said today that one of these two witnesses must have been honestly mistaken.
Mr. Mandy then went on to speak about phone A and phone B. As another reminder for our listeners, phone A was Erin's usual phone, which the prosecution alleged she concealed from police, while phone B was the dummy phone it alleges she set up to hand to police.
But Mr. Mandy questioned today why Erin would go to the effort of setting up phone B just to hand it to police as a dummy phone. He said as soon as investigators looked at the phone, they would have realised it was not her usual phone. He reminded the jury of her evidence that she set up phone B because phone A was damaged and she wanted to change devices. This is what he said about the allegation from the prosecution that Erin concealed phone A.
If the intent was to conceal the existence of phone A, why continue using it? Better yet, why not get rid of it at a much earlier stage? She had the opportunity to dispose of it after she got home from hospital. Why not take it to the tip? If she had planned the cold, calculated murders that the Crown says she committed, deliberate murders the Crown says she's planning at least from 28 April, and had incriminating searches on her phone, this would have been part of the plan, surely. It would have been destroyed.
He said the fact Erin continued to use phone A after the lunch was more consistent with her account, telling the jury that the prosecution were only alleging she concealed phone A to explain why certain evidence in the case did not exist. He did admit that factory resetting phone B was a stupid thing that his client did, but he said it remained consistent with her panicked state of mind.
His Honour will direct you, as a matter of law, that the law recognises that there might be all sorts of reasons why a person engages in conduct that to everyone else in the outside world may make them look guilty. There are all sorts of reasons why an innocent person can engage in that type of conduct, like dumping the dehydrator and lying, and you now have those reasons. Erin got into the witness box and told you she did those things because she panicked when confronted with the terrible possibility, terrible realisation, that her actions had caused the illnesses of people that she loved. It doesn't excuse what she did, not making an excuse about it. You can't jump from there to what the Crown wants you to conclude from those items of evidence.
Mr. Mandy then turned to discussing Erin as a witness. He reiterated that she did not have to give evidence.
She subjected herself to lengthy cross-examination and our submission to you, and you would probably agree, that the way she answered questions was careful, even pedantic. And you might think that's a very sensible way of approaching things if you are going to be cross-examined for 6 days. It is difficult to imagine a situation where you would be placing yourself under such an incredible amount of scrutiny. But she still made the decision. She didn't have to do that, and when she chose to do it, she made that decision as an innocent person, because that's what she is right now, and has been throughout the trial, presumed innocent of all the charges.
Mr. Mandy said she told the truth, even when it was deeply embarrassing, and had to admit she told lies. He declared that his client came out of the extensive cross-examination unscathed.
Her account remained coherent and consistent day after day, even when challenged rapid-fire from multiple angles repeatedly. So the significance of her evidence is this, that His Honour will give you a direction of law about the conclusions that you might reach from Erin giving evidence. First, if you think her evidence was true, you must find her not guilty of all of the charges. Second, if you're not sure whether her evidence was true, but think it might be, then you will have a reasonable doubt on the prosecution's case and you would find her not guilty of all the charges. Third, if that's not enough, that you prefer the prosecution case to her evidence, balancing those two things, prosecution a little bit better than Erin, that's not sufficient, because that would be finding that the prosecution case is preferable to the defence case. And it's not a question in this case, I'll come back to this in a minute, not a question of balancing two things.
It was at this point that Mr. Mandy took the jury to the convoluted and ridiculous propositions he said were made by the prosecution that we flagged at the top of the episode. He said that there were at least 4, telling the jury that it was ridiculous that Erin would commit murder without any motive to do so, ridiculous that she would use cancer as a lie to get her guests to attend her lunch, ridiculous that she expected the guests to take her secrets about her medical issues to the grave with them, and ridiculous that she would push ahead with her plan despite knowing she would be in the spotlight as the cook. He then borrowed a metaphor used by Crown Prosecutor Nanette Rogers in her closing address earlier this week. She referred to the case as a jigsaw puzzle that they must piece together. But Mr. Mandy said today, to force the evidence to fit the image on the puzzle box was like working backwards from a place of assumed guilt.
You can't force jigsaw puzzle pieces together. When puzzle pieces don't fit naturally, when you are making the picture, you've got the wrong picture, the wrong piece in the wrong spot. It is not fitting naturally into that gap.
As he approached the end of his closing address, he told the jurors they could not decide the case by asking themselves whose case is better.
It was at this point that he mentioned the sporting analogy you heard at the top of the episode. He spoke to the jury about the legal principles our criminal justice system relies on, including the standard of proof, beyond reasonable doubt. He said these principles of a criminal trial were like the golden rules, which protect us all from being wrongfully convicted. He then launched into his final statement to the jury.
If you think that it's possible that Erin deliberately poisoned the meal, you must find her not guilty. If you think that maybe Erin deliberately poisoned the meal, you must find her not guilty. If you think that she probably deliberately poisoned the meal, you must find her not guilty. If you think that it's possible that she intended to kill or cause really serious injury to Don or Gail or Heather, you must find her not guilty. If you think maybe she intended those things, you must find her not guilty. If you think probably she intended those things, you must find her not guilty. And if you think that it's possible Erin intended to kill Ian, you have to find her not guilty. Maybe she intended to kill Ian, not guilty. Probably not guilty. If you think at the end of your deliberations, taking into account the arguments that we've made, that it is a possibility that this was an accident, a reasonable possibility, you must find her not guilty. And if you think that it is a reasonable possibility that her evidence was true, you must find her not guilty. And our submission to you is the prosecution can't get over that high bar of beyond reasonable doubt.
And with that, Mr. Mandy was done. So after 8 weeks and more than 50 witnesses, the jury has now been sent out to rest before Justice Bill delivers his charge.
And you mentioned the word rest there, Brooke, and that's because the jury have a long weekend. They won't be required to come back until early next week. So Justice Bill told them to actually think about it like a second Easter. I think they were very relieved to have some time off before they begin their deliberations next week.
You're right about that, Laura, but in the meantime, go to themushroomcook.com.au for more.